Afternoon. This is Alana Kirk with the Health Policy Institute of Ohio. Thank you for joining our webinar on the Ohio Addiction Policy Inventory and Scorecard, Law Enforcement in the Criminal Justice System. This webinar is being recorded and slides from today's webinar will be posted on HPIO's website. Right? The vision and mission of HPIO is to influence the improvement of health and well-being for all Ohioans, to provide the independent and nonpartisan analysis needed to create evidence-informed state health policy. We do want to thank our funders for their generous support of our work, as well as our forum sponsors for their support of our forums. HPIO will be hosting forums online this year, and to receive the latest updates about publications, resources, and forums from HPIO, please join our mailing list by visiting the HPIO website and clicking Sign Up under Stay Informed. Okay. We will take questions at the end of the webinar, and you can use your question box for that. We do want to know who is on the call today, so we will have a poll for that. So please let us know if you are with behavioral health, with the other healthcare providers, public health, law enforcement, or a different sector altogether. We'll give you a second for that. All right, it looks like the majority of you are in other sectors. We do have 3% from behavioral health, 13% from other health, and 30% from public health, as well as 13% from law enforcement. We appreciate you all for being here today. All right, today you will hear from the authors of this report, Amy Bush Stevens, Vice President at HPIO, as well as Haley Aka, Policy Analyst at HPIO. Our agenda for today, we will cover the key findings of this report, discuss the impact of COVID-19 in Ohio jails and prisons, and we'll also hear from a guest speaker, Senator John Eklund. With that, I am going to give it over to Amy Bush Stevens.
Thank you, Alana. Good afternoon, everyone. This is Amy Bush Stevens at HPIO. I'm going to start off by setting some context and then turn it over to Haley to get into the key findings from our scorecard report, and then we will hear from Senator Eklund. As we worked on this project for the scorecard, 3 questions came to mind that will be helpful for us to think about today. The first is, what is the purpose of law enforcement and the criminal justice system? Second, what is the purpose of the behavioral health system? And what happens when these 2 worlds collide? Like many of you on the webinar today, we are most familiar with the behavioral health system. The purpose is straightforward: prevention, treatment, and recovery. And there's generally a view of addiction as a chronic, relapsing disease in need of long-term chronic disease management. It's a bit more complicated when we look at the purpose of law enforcement and the criminal justice system. In particular, there's a tension between the last 2 bullets here. Is the purpose to punish lawbreakers or to rehabilitate offenders? And are people involved in drug crimes bad or sick? This unresolved tension will be a theme in what we talk about today. So what happens when these 2 systems come together? This is important because they come together a lot. Most people who are incarcerated have a history of drug use or substance use disorder. And we've seen an increase in drug-related crimes in recent years in our state. We've thought a lot about what it means when these 2 systems come together and what the aims or desired outcomes should look like. There's pretty widespread agreement on the first 5 bullets in this box, but again, there's some tension between the last 2 here. The sequential intercept model is a helpful framework for thinking about these interactions and strategies to improve outcomes for justice-involved people with addiction or mental illness. This model, which I'm sure many of you are familiar with, shows the sequence of how people move through the criminal justice system, and we use it to organize the scorecard report. Throughout this webinar, please be thinking about these 3 questions, plus this overarching question. How can we improve outcomes related to addiction, public safety, criminal justice, and equity? That's really the policy challenge before us, is how do we get to improved outcomes in all of these areas? Now we're going to share the scorecard report with you, and I'll first talk about some of the background and process, and then Haley will share key findings. Before we get started, there are 3 important challenges I want to mention: incarceration, inequity, and data gaps. Ohio has a higher incarceration rate than the US overall. In 2017, we were in the 3rd quartile. And on this map, red means the 3rd quartile, and green means lowest. So red means higher incarceration rates, and green means lower incarceration rates. And keep in mind that the US has the highest rate of incarceration in the world. So here in Ohio, we have high rates in a country with the highest rates. This is expensive for our state. This first number here is the cost of a 4-year tuition at a 4-year university in Ohio, which is obviously a big number. But if you look at the next number, that's the cost to incarcerate someone in a state prison, about $27,000 a year. Multiply that by the 49,000 people that we have in state prisons currently in Ohio, and you can see that that adds up. The second challenge is inequities in the criminal justice system. We see huge disparities by race for incarceration, and the same pattern holds true for arrests. So that must mean that more people of color use drugs, right? Not at all. Despite the large disparities in drug crime, arrests by race, drug use and addiction prevalence are pretty similar across racial and ethnic groups. These racial inequities in the criminal justice system are deep and systemic in our country. They continue to be a clear example of institutional racism. This goes back to slavery and Black codes and convict leasing. Black codes were criminal codes meant to restrict the activities of African Americans. Convict leasing was the practice of leasing incarcerated people to plantations and factories after the Civil War. These disparities are also rooted in more recent history, including the war on drugs. From the 1960s to the 1990s, there was bipartisan support for a series of tough on crime policies. That resulted in dramatic growth of our prison population, known as mass incarceration, which disproportionately affects men of color. The third challenge to keep in mind is the troubling lack of standardized data in law enforcement and the criminal justice system. One of the most striking things that we learned in working on this project is how little information policymakers have to go on when they're making decisions about law enforcement and criminal justice. But there is hope. We do see improvements being made in data that's being collected around the state, such as work being done by the Supreme Court of Ohio to look at data for drug courts. Now we'll take a closer look at the scorecard. This report we released in November of 2019, and I want to take a minute to thank our advisory group for this project and this publication specifically. They're listed in the back of the report, and we really appreciate their guidance. This scorecard report is part of the Addiction Evidence Project series The goal of this work is to provide policymakers and other stakeholders with information needed to evaluate Ohio's policy response to the addiction crisis and continually improve what we're doing. There are three aspects. This is the framework for the Addiction Evidence Project, which acknowledges that there are many sectors critical to addressing addiction. There are three aspects of each phase of the Addiction Evidence Project that are listed here. The main takeaway is that for each scorecard report, we look at the evidence for what works, compare that to an inventory of what the state has done, and then develop a scorecard to show the strengths, gaps, and opportunities for improvement in Ohio. This is a summary of what that scorecard looks like for law enforcement and criminal justice. And now I'm going to turn it over to Haley to highlight some of the key issues we identified as we pulled this information together. Take it away, Haley.
Awesome. Thank you, Amy, for providing that context and background. And thank you so much to all of you for being here with us this afternoon. We know that everyone has a lot going on. I am going to talk about some of the things that Ohio policymakers can do to improve both addiction and criminal justice outcomes here in the state. I'm going to focus on these three areas because they're particularly timely and relevant to state policymaking right now. And for each of these three areas, I'll briefly describe the policy strengths and gaps, and then identify some opportunities for improvement. First, we'll start with community services that law enforcement agencies provide for people with addiction. Looking back at that sequential intercept model that Amy introduced for us, community services is all the way at the beginning at intercept 0. Intercept 0 is any law enforcement activity that's purpose is to prevent an individual from becoming involved in the criminal justice system in the first place. So this involves proactive police responses to vulnerable populations, including people who have experienced drug overdose. This is critical, as we know, because the rate of drug overdose remains high in our state. This map shows data from the CDC that looks at rolling 12-month averages. This is the period from July 2018 to July 2019, looking at the percent change in overdose death. And although previous data had shown a decrease in overall overdose death in Ohio, we actually saw a little increase in deaths in this most recent data. Some areas of the state we know have seen consistently high numbers throughout, but what this data tells us is that we really do have more work to do to respond to overdoses early and to prevent them whenever we can. One method that law enforcement uses to respond to overdoses is the ODMAP system. ODMAP is a mobile app that provides near real-time data on drug overdoses, which allows public safety and public health agencies to collectively identify and respond to spikes in overdose events and to overdose hotspots in their counties. Quick response teams or drug abuse response teams are another community service offered by law enforcement, and you'll hear me refer to these as QRTs and DARTs. These teams pair first responders with behavioral health providers and other community partners to follow up with overdose survivors to help engage them in treatment. So our strengths and gaps in this area. As of this month, 242 agencies in 76 counties are using that ODMAP system. That 242 number includes both first responders and public health entities. The QRT or DART model is also taking root across the state. For instance, in the 2018-2019 state budget, there was $3 million of funding that was allocated to law enforcement agencies to expand this model, and 40 police departments were awarded that funding. So we know this work is going on. Unfortunately, we do not have data that tells us the number of local law enforcement agencies that have implemented a QRT or a DART program. So we're unsure of the reach there. And then for ODMAP, we also don't know how many counties are proactively using that system to facilitate information exchange and partnership with their public health departments. Each county, law enforcement agency in that county determines the level at which they want to participate with ODMAP, and the data on how extensive that participation is not publicly available. And then finally, Ohio does not require law enforcement officers to be trained on addiction, and the number of law enforcement agencies that have voluntarily provided that training is not known. Lots of things that we don't know. I'm going to add one additional thing in this law enforcement sector, and that has to do with Ohio's incident-based reporting system. The OIBRS is the standard data collection system for crime data across Ohio, but participation in the system is voluntary. So in 2014, there were 539 agencies participating in the system, which covers about 73% of Ohio's population. Those agencies cover 73% of Ohio's population. So not full participation, as we can see. Lack of that full participation makes it really difficult for state policymakers to get a full understanding of the law enforcement issues that are facing our state. So with all of that in mind, here's a summary of the opportunities for improvement that we identify in the report. First, we can expand ODMAP so that all first responders and public health agencies are partnering to address overdose spikes in their counties. Second, we can collect that data on the number and reach of the QRT and DART teams in the state, so we know what's happening with those teams. And then finally, the state could require OIBRS reporting from all law enforcement agencies and provide them with that funding so they can collect that data in addition to all the other things that our law enforcement agencies do. The second key finding is related to pretrial diversion and the bail system. Following along on our sequential intercept model, we are now at intercept 2, initial detention and initial court hearings. So these are an individual's first steps through the criminal justice system after they've been arrested, but before they've been convicted of a crime. And there are strategies that can be implemented in this early stage that redirect individuals who are struggling with addiction out of the criminal justice system and into treatment. These strategies are called pretrial diversion. And these are alternatives to incarceration that allow defendants who are charged with drug crimes or who were under the influence of a drug at the time of their incident to either enter rehabilitation or some other treatment that's aimed at addressing those underlying causes of the criminal behavior. In Ohio, we have 3 methods for pretrial diversion. All of them are limited to low-level nonviolent offenders. You'll see, for example, that last bullet, the TCAP program. This is Targeted Community Alternatives to Prison. And this is where Ohio Courts of Common Pleas can apply to the Department of Rehabilitation and Correction at the state so that the county can supervise and provide treatment services for those individuals and hold them accountable at the community level and not in the criminal justice system. Unfortunately, there's no data available on how often pretrial diversion is offered to defendants or the demographics of the defendants that are typically served by these programs. So even though these programs are available and they're expanding, there's a lot we don't know about how they're being implemented or their effectiveness in diverting offenders to addiction treatment. Another aspect of this early part of the criminal justice process is initial detention and the bail system. Ohio, like most other states, uses a cash bail system. Cash bail is that money that defendants or their families have to pay as a deposit in order to be released from jail after they've been arrested, but before they've been convicted of a crime. And this is to ensure that defendants will reappear for court or for hearings. Cash bail is not an evidence-based tool for any stated aim of the criminal justice system. It keeps people in jail, in debt, out of the workforce and away from their families before they've been convicted of a crime. So while our system still presumes their innocence. And although there's some bipartisan agreement on that point, there's much debate about the best ways to reform the bail system or if it should be reformed at all. Some advocates have called for a risk assessment tool to replace cash bail. These tools use crime data and other information to assess who is likely to present in court and who is not. Others have said that these tools are inherently biased because of concerns that racial discrimination is baked into the crime data that these tools are based on. And still others say that reforming bail in this way will release too many people from jail pretrial and will make our communities less safe. So we still have a long way to go before we have an agreed upon alternative to the current bail system. Our strengths in this area. A strength is that we have those three pretrial methods, those three methods for pretrial diversion. And we're also requiring jails to screen detainees for use of alcohol and drugs upon initial detention, which can lead to connections to treatment. Our pretrial diversion methods, though, are not available to everyone who would benefit from them. Offenders who have committed violent or high-level felonies due to addiction are not eligible for pretrial diversion, and whether qualifying offenders have access to these programs is really up to the discretion of the prosecutor or the judge in many cases. And then finally, Ohio utilizes a money bail system, which is not an evidence-based tool for pretrial release and detainment decisions, as we discussed. So here are those opportunities for improvement in this area. We can expand the TCAP program to all counties and reduce the number of conditions that make offenders ineligible for that program. We can collect data on pretrial diversion so we know who's getting access to those programs and how often they're being used. And then finally, we can reform the money bail system and implement a culturally competent risk assessment tool that could assist with pretrial and release decisions. This tool would need to be designed so that unintended consequences related to racial and other inequities are minimized. Our final key finding is related to addiction treatment in prisons and jails. We are now in Intercept 3, which is all about prisons, jails, and courts. There's this bridge between substance use disorder treatment and the criminal justice system. Addiction treatment is necessary for all people struggling with addiction, but for people who have committed crimes as a result of addiction, the criminal justice system can be that place where treatment is provided, that can rehabilitate offenders, and that can set people up to be successful in long-term recovery. And this can happen both in prisons and in jails, so we'll look at both of those systems in turn. Prisons are longer-term corrections facilities for people convicted of felonies and individuals with sentences longer than 1 year. Ohio State prisons are funded and operated by the state. We do have one federal prison here in the state as well. When it comes to addiction treatment and overdose reversal, prisons tend to offer evidence-based care to the people incarcerated with the state. All DRC employees are trained on naloxone administration, storage, and record keeping. Screening is included in the treatment regimen for all offenders. We're not quite sure the extent to which that's happening. That data is not available, but it is part of the standard treatment that's happening in the prisons. And then finally, with treatment, the Bureau of Correctional Recovery Services offers offenders with SUD a variety of treatment services, including medication-assisted treatment in some places. On the other hand, jails are locally run and funded. They're used as short-term holding facilities for recently arrested individuals or for individuals awaiting trial, like we previously discussed with bail. They're also used to incarcerate inmates sentenced to less than 1 year of imprisonment. And in contrast to our prisons, jails do not always offer the addiction treatment that people need. There is no requirement for local jail employees to be trained on naloxone administration. With withdrawal management, this is a significant concern for jails because this is where individuals are first brought after arrest and where they're likely going to detox. All full-service jails are required to develop policies to address symptoms of detox from drugs and alcohol. However, there's no data collection related to this, and there are few enforcement mechanisms to make sure that that's happening throughout the state. And then finally, the jail standards do not require evidence-based addiction treatment, and we know that there's variation in the types of treatment available among Ohio jails. What jails are required to do is laid out in the minimum standards for jails, and DRC's Bureau of Adult Detention is responsible for monitoring jail compliance with those standards. The standards, though, are not very specific when it comes to screening and providing treatment for addiction. The standards say that all inmates must be screened for physical and mental health conditions upon arrival, including for use of alcohol and drugs. There is no specific standard for screening for substance use disorder, appropriate use of naloxone, medically managed withdrawal, or evidence-based SUD treatment. There are also significant gaps in what we know about addiction because there is no standard data collection system for our jails. Individual jails are keeping their own records, and so we've heard anecdotally that in some places these records are even kept on paper, right? So it's very difficult to know from a state perspective what the strengths and challenges are when it comes to addiction treatment in the jails, because there's simply a lot we don't know about what's going on in that system. I'll tell you the strengths and gaps that we can identify though. Strengths include that naloxone is available in all Ohio state prisons and that prisons are offering SUD treatment to inmates. Gaps are that there's significant data gaps on addiction screening, treatment, and withdrawal management in jails, and that those minimum jail standards are not specific or actionable enough to adequately care for the folks detained and incarcerated in local jails. Here are the opportunities for improvement that we've identified here. We could update the jail standards to require more specificity for how to provide addiction treatment for incarcerated individuals. We could institute a standard data collection system across Ohio jails that we can fill in some of these data gaps that we see. And then finally, we can increase training requirements for corrections professionals so that all employees in prisons and jails are trained on addiction, evidence-based treatment, stigma, and implicit bias. So those are some of the key takeaways, key findings from our report, those three that we just went through. We'll end this portion of today's webinar with the overall key takeaways that we have for our policymakers out of this report. The first is that we're moving in the right direction. We're implementing some of those evidence-based practices in the law enforcement and criminal justice sectors that can help. Second, there are some systemic issues in the criminal justice system that mean more needs to be done to reduce the number of people with substance use disorder in the system and to reduce inequities. And then finally, policymakers really don't have all the information that they need to comprehensively address addiction and inequities in the criminal justice system because of these large data gaps that we see throughout. So I want to leave you all with a few current efforts that are going on in the state to address some of the issues that we see with addiction in the criminal justice system. I'm not going to go through all of these. We want to get to the COVID-19 piece and hear from Senator Eklund, but you can peruse these at your leisure. I will point out that Senate Bill 3, the first one that you see in the top left, is what we're going to be discussing later with the senator on today's webinar. If there are a couple of questions, maybe one or two that we could take at this point, specific to the report and the key findings from the report, now would be a good time to do that, Alana. If maybe there's one or two that we should do as a group. If not, I just want to let you all know we see that there are questions popping up in the question box, and we can take time to respond to those in the chat box itself if we don't have time to do them together on the webinar.
We do, this is Amy. We do have one question in the chat box, and this is from Stephen Dunn, and he is talking about how there is often resistance among law enforcement to carry naloxone, and he asks, why can't the legislature or governor put this into place and make it mandatory for all law enforcement to carry naloxone, and how do we break down the stigma, especially when data shows Ohio is at higher rates of overdose? And I think this is a really important question. It also connects to the earlier scorecard report that we did on overdose reversal, where we talk a lot about naloxone distribution. I think the short answer to the question is local control. I think for the most part, decisions about when and if and how law enforcement carry naloxone has been left to local jurisdictions. And so I think there's wide variety across the state in that. Anything to add, Haley? That's our only question.
Okay, great. The only thing I'd add, there's that piece about how do we address the stigma related to that. So Amy's absolutely right. That's the practical reason why there's differences at the local level. I think continuing to build these bridges and partnerships between local public health and law enforcement will continue to educate folks across the state about the importance and the benefits of these things. We know that there's folks working tirelessly across the state to get naloxone in the hands of people that need it. And pulling law enforcement into those conversations could be an important step to breaking that stigma down. Okay, well, great. If we have no other questions at this time, keep throwing those in the question box. We'll have another opportunity for questions at the end. But we'll now move forward to talking a little bit about the current pandemic and how it's impacted incarceration and incarcerated populations here in Ohio. Governor DeWine has said that the state is concerned about all settings where people are living in close proximity during this time, like prisons, nursing homes, other congregate settings. There are particular reasons that we should be concerned for people who are incarcerated, corrections workers, and their families during this crisis. And we'll talk about a few of those now. When compared to the general population, people who are incarcerated tend to have worse physical and mental health outcomes. Research indicates that people who are incarcerated in prisons and in jails are more likely to have high blood pressure, asthma, cancer, arthritis, and several infectious diseases like hepatitis C and HIV. Unfortunately, recent studies are also showing that several of these conditions, the ones that you see on your screen, are also comorbidities that put people at higher risk of negative outcomes related to COVID-19. So this means that prison inmates who contract COVID-19 are more likely to have severe cases of the disease. Not only that, but incarcerated populations have a much harder time preventing the spread of infectious disease because social distancing is so difficult in these settings. This is an image from Lancaster Prison in Southwest Ohio. And you can see that prison inmates are sleeping within 3 feet of another person in all directions. People detained in state prisons also come from all over the state, and staff and other individuals are coming and going from prisons with regularity. And any of these individuals could be bringing the COVID-19 virus into the prison with them. So because of the likely severity of the illness among incarcerated populations, and because the spread within these settings is so hard to prevent, special focus is really needed to maintain the health and safety of prison inmates, staff, and their families during this time. There are several ways that state policymakers can address these concerns. They could reduce the number of people entering prisons and jails. They could work to protect the health of inmates and staff that are currently in these settings, and they could release people from prison or jail early before the ends of their sentences. Interim guidance from the CDC advises states on policy options in those first 2 buckets, reducing the number of people entering incarceration settings and protecting the folks who are already there. This guidance includes recommendations on operational preparedness, preventing the spread of disease within facilities, and how to manage confirmed and suspected cases of COVID-19 once they are in the jail or prison setting. All of these recommendations are available here on the CDC website. You can take a closer look at those. Additionally, the National Commission on Correctional Healthcare has put out best practice standards on how corrections facilities can prevent and control the spread of infectious disease, including COVID-19. This includes information about pre-screening new inmates, social distancing in cells and in common areas, and quarantining those who test positive or exhibit symptoms. Again, all of this information is available on their website that you see here. And now I'm going to turn it back over to Amy, who's going to walk us through some of the things that the state of Ohio has done to address the spread of COVID-19 within the criminal justice system.
Thank you, Haley. I'm going to talk about the current status of what we know about COVID-19 in state prisons and then county jails. And we'll take a look at the state level policy response so far in these 3 buckets. The Department of Rehabilitation and Correction, DRC, has been sharing data about COVID-19 in state prisons. And you can find this information. This is a screenshot from the website that you can access through the Department of Health's coronavirus website. And they're providing daily updates on the number of inmates and staff who test positive or who have died. As of yesterday, they're reporting 146 cases among inmates and 1 inmate death that we know of, and 119 staff cases and 1 staff death. On March 29th, DRC announced safety measures. These include suspending visiting and screening all staff upon entry. We have also heard through media reports of prisons going down to 2 meals a day, and also changes in access to video calls and calls with visitors. Obviously, now that visitors are restricted, finding other ways to maintain connections between inmates and their families is very important. Similar information is posted through the ODH website for the Department of Youth Services facilities. And looking at that data, they're reporting 0 positive cases as of yesterday. We have less information here today on federal prisons, but I do want to point out that at the Elkton Federal Correctional Institution, there have been some reported cases and deaths, and the governor has mobilized the National Guard to help out with medics at that facility, and the ACLU and the Ohio Justice Policy Center recently filed a class action petition on behalf of those inmates. On his daily press conferences, the governor has announced efforts to reduce the state prison population, but the categories of inmates that are being considered for release so far have been quite narrow, resulting in a small number of inmates identified for release. So there was a story in the Dispatch this past weekend that reported that 0.42% of Ohio state prison inmates have been identified for possible early release. So we're talking about some small numbers. Since we're focused today on addiction, it's important to note that the list of charges that are not eligible for early release, such as sex offenses, domestic violence, and homicide, do not include drug crimes. So it appears that people in prison for drug crimes are being considered lower risk and more favorable for release. Now we'll take a look at county jails, some of which also serve as immigrant detention centers, so they have ICE detainees. So remember the screenshot that I showed a minute ago with the DRC website with the number of cases and deaths by facility. We don't have anything like that for the county jails. We haven't seen any central data reporting where we can really have a good look at what's happening in our jails across the state. We have seen from media reports that there are, as of April 3rd, there were 6 Cuyahoga County Jail inmates who tested positive, 2 in the Franklin County Jail. We also have seen in media reports that many jails are reducing their prison populations. There's some examples here on this slide. We've also heard that jails are screening employees, sanitizing their facilities, but we don't really have a good sense of to what extent do jail inmates have access to soap and water and sanitizer and other best practices recommended by some of the sources that Haley talked about. For the state level policy, there are 2 important documents from the state to locals that provide guidance. On March 15th, the director of ODH issued guidance to jails to restrict access to necessary personnel only and to not allow visitors, to screen people coming in for fever and other symptoms, and to comply with infection control precautions. So that's the order on the left. And then on the right, on March 30th, the Ohio Supreme Court issued guidance to local courts to minimize the spread of COVID-19. And they included several recommendations designed to reduce the jail population, both in terms of reducing the number of people going into jail and also releasing people from jail. And these include some pretty big changes, including releasing people pre-trial without money bail and releasing nonviolent misdemeanor inmates to electronic monitoring. And again, those are recommendations. It is up to the locals to decide how to act on those. To wrap this section up, I want to pose some questions and considerations for what this means for addiction, particularly in the first and last bucket here. So what does this mean for drug courts, for sentencing reform? We're going to hear about SB3 in a minute. For reentry programs, and what will we learn from this basically natural experiment that's underway, where we are not putting as many people who have committed drug crimes into jail, and we are letting out of prison and jail some people who have committed drug crimes. It's obviously too soon to have answers to these questions, but they will be important to address going forward. And now I'm gonna introduce our next speaker. I do see we have a few questions coming in, but I want to make sure that we have adequate time for Senator Eklund. So I'm going to introduce him, and then we'll circle back to questions at the end of his remarks. Senator Eklund represents the 18th Senate District, which covers parts of Geauga, Lake, and Portage counties. He's the chair of the Senate Judiciary Committee. He's an attorney with over 35 years of legal experience. And most relevant for this conversation, he is a primary sponsor of Senate Bill 3 to reform drug sentencing laws. And now I'm going to turn it over to Senator Eklund.
Thank you very much, and thank you for allowing me to be with you all today. And thank you for what all of you folks do on a regular daily basis to try to advance the cause of sensible judicial system and criminal justice system reforms. It's terribly, terribly important stuff. Let me begin with Senate Bill 3 by describing a little bit about how it came about, because before there was a Senate Bill 3, of course, there was County Prosecutor O'Brien and Columbus Prosecutor Klein had come out with a proposal, and before that, or around the same time, the Ohio Criminal Sentencing Commission had come out with a proposal on drug sentencing. And of course, in the fall of 2018, issue 1 was on the ballot statewide that dealt with this topic as well. But even if you go back even before that to 2016 and 17, there was the Ohio Criminal Justice Recodification Committee, on which I was privileged to sit along with many other people, and we went through the entire criminal code and made a series of proposals to reform it. On the area of drug crime reform, what became pretty striking to me during that process is that there apparently is a correlation between the amount of illicit drugs one possesses and what happens to those drugs. Are they used for personal use? Are they shared with one's friends and family? Are they sold to support the individual's addiction? Or are they sold as part of an entrepreneurial business, an illicit, illegal business? And so the whole point of it was, depending upon the volume of drugs that are involved in a particular situation, there is the ability to predict with some degree of confidence, if not certainty, whether this is simply a possessor, user of drugs, or is this someone who's engaged in a commercial enterprise with those drugs? And the idea formulated in the Recodification Committee was, if that in fact is valid, then we should deal with the question of drug crimes in a more differentiated way than we have been up until this point. And that's fundamentally what the foundation of Senate Bill 3 is. Now, I should point out that Senate Bill 3 was not conceived to be, and is not today conceived to be, at least not by the sponsors, a recipe for reducing prison population. The fact is today that most drug possession cases do not result in people going to prison. Between TCAP and between other diversionary programs, there are considerably fewer possession drug cases that are sending people to prison. So it's not about that, but rather it's about removing the stigma of a felony arrest and conviction so far as we're able to do that consistent with public safety. And we do that because honestly, we believe that there is a certain humanity in providing the opportunity for, and that most human beings have the ability to seek and to achieve redemption. And it's about taking time to understand that people shouldn't have a stigma simply because their biggest crime was succumbing to the allure of drugs, and giving them the opportunity for the redemption that I believe all humans are capable of. So how do we do that? It's really quite simple fundamentally. Under Senate Bill 3, possession of lower levels of all drugs would, instead of being felonies, would be classified as unclassified misdemeanors with a maximum punishment for those crimes up to 364 days in jail, not in prison, in jail. But at the same time, for those possession offenses, their cases, that is the criminal case, would be eligible to be held in abeyance and stayed, so there are no criminal proceedings that go on. And if the defendant performs under a treatment plan prescribed by the court and successfully does so, that case would be eliminated from the system. There would be no arrest record, there would be no conviction record, there would be nothing. And with that, we believe could go a long way towards incentivizing people to stick with the treatment programs. Now, there are exceptions where some cases won't qualify for that kind of treatment, but the vast majority of them, we believe, will. Now, with regard to trafficking offenses under the bill, we recategorize the trafficking offenses into 3 levels: trafficking, major trafficking, and aggravated trafficking. And with increasing numbers of amounts of drug, it becomes a more serious offense. No surprise there. But one feature of the bill that people tend to overlook is that for the trafficking offenses, again, consistent with the findings that we made at the recodification committee, the more of the drug you have, then there's going to be a presumption that you are trafficking, that it's not going to be required to prove the usual trafficking conduct that has to be proved today: sell or offer to sell, preparing for shipment, transportation, delivering, preparing for distribution, that sort of thing. All of those trafficking conduct will not be required to be convicted of trafficking if you're in the trafficking category as far as how many drugs you have. So that's a great advancement, I think, for purposes of law enforcement, and to really put another tool in their tool belt to really go after serious distributors of drugs. I would say to you that, believe it or not, I mean, it's a long bill and it's taking a long time, but most of the other things that are in the bill, I would regard as kind of mechanics. Like which courts will hear these new unclassified misdemeanor offenses? How do we make sure that if we pass this bill, we're not stepping on the toes of the drug courts around Ohio that are very, very purposeful and useful? There's a question that continues to abide about the extent to which we should make the bill have retroactive application. We have changes in the bill also to facilitate and make more user-friendly, I would say, the civil commitment process for people who are a danger to themselves because of drug or alcohol addiction. And by the way, speaking of data, which we've heard a little bit about earlier today, or the lack thereof, the bill would authorize the Ohio Criminal Sentencing Commission to have access to the LEADS database for purposes of analyzing and reporting on the impact, if any, that Senate Bill 3 has in the years going forward. So there's an effort to be responsive to some of the concerns that have been expressed about a lack of data. I've been asked to opine on what the prospects for the bill are at this point, and I will tell you all, in all candor, that it has been and will continue to be a rather rough and steep path to have this bill become law. The prosecutors of Ohio are against it. The Ohio Supreme Court's Chief Justice is against it. Law enforcement folks locally are against it. They believe that it will increase the cost of operating their jails, notwithstanding that the whole point of the bill is to keep people out of jail, but that's their point of view. The Chief Justice has expressed the view that if you turn these offenses into unclassified misdemeanors, that no one will have any incentives to follow a treatment program. And for the life of me, I cannot understand why the threat of a felony is going to compel somebody to get well when losing your family and running the risk of a premature death every time you use drugs doesn't seem to faze some of these folks either. When you add to that the COVID-19 situation, I have to say again that I fear, not fear, but I suspect that we will see once we get up and running again in the legislature that there are going to be a number of legislative proposals, some of which at the direction of the administration to try to clean up messes that have been created by government action in the first place. And those are very dangerous circumstances in which to make legislation, I have to tell you, because the sense of urgency tends to overcome a sense of caution, and things that otherwise might be perceived as important, like Senate Bill 3, like House Bill 1, like House Bill 136, I believe it is, sometimes get shuttled to the side because unfortunately, the legislature, in case you hadn't noticed from time to time, seems to lose its ability to chew gum and walk at the same time. And I can tell you, I don't know what's going to happen, but I know that Senate President Obhoff is committed to Senate Bill 3. And I can assure you that I am and will not rest until we've had the opportunity to get it across the finish line. So with that, I'm probably running out of time and your patience perhaps, but I've appreciated the opportunity to share this with you, and we'll be happy to answer any questions if the host thinks there's time. Thanks so very much again.
Thank you so much, Senator Eklund, for that update. We do have just a few minutes here for questions. I do see one question comment here on Senate Bill 3 from Kathy Payton. She says, I think the short-term costs of Senate Bill 3 are worth the long-term savings and rehabilitation of individuals.
Well, thank you very much for that. And I couldn't agree with you more. And it's terribly, terribly important. And look, and I don't know what the cost is going to be. And I would be, you know, people ask that all the time. Well, how much is it going to cost? And to me, I don't know. Let's do this. Let's do something purposeful. And if it needs to be adjusted in some fashion or way down the road because of a cost or because of an unforeseen consequence, well, we'll deal with it. But there's no reason to be ossified.
All right, I'm looking to see if we have any more questions regarding SB3. Haley, do you have anything else to add? I'm not seeing any more SB3 questions.
No, looks good. Oh, we've got one coming in.
I did see a question earlier, I think that was aimed at me, that was about the going to 2 meals a day in prisons and why that's the case. I believe that was to reduce contact because meal times are a time when there's more contact between inmates. I think that was the rationale. Okay, now we do have a question here from Jack Lynch. How will SB3 direct people to treatment programs? Senator, can you answer that?
Yes, in the case where the case is eligible for the being held in abeyance and stayed, the court will work with professionals associated with the court and in the community to develop a program for the individual who's been arrested for one of these possession offenses. And that'll be supervised, and the performance of that will be overseen and supervised by public health people, as well as community corrections organizations, and of course, parole folks, parole officers. So it'll be a kind of a team effort to get the person into the BRIGHT program and to oversee their performance, just as we do in many respects through the drug courts today.
All right, thank you for that. I am not seeing any more questions.
All right, and in the interest of time, I think we should go ahead and move us to the closing slides of today. Thank you so much, everyone, for joining us, and thank you so much, Senator, for providing that update. We want to leave you all today with our key takeaways for our policymakers again, so that you have those to review. Moving to the next slide, we also want to let you know that there are ways that you can be a part of this effort by sharing the report with your contacts, by selecting some of the opportunities for improvement that you see in the report, and having conversations with your policymakers about those. And then finally, by continuing to partner with folks in the addiction treatment world, in harm reduction, in law enforcement, and criminal justice. Really, the only way that this work moves forward is if we solve problems together. So thank you guys for being engaged in this. We are going to throw one last poll for you all today. We just would love to know how you think we did on today's webinar so that we could have some feedback to take back with us. You could also drop us comments in the question box if you think that there's something we could do to improve, or if you want to let us know how we did today. We're really working hard to make sure that we're getting good information to you guys in a way that's helpful. So thank you for answering this poll and letting us know how we did. We're going to leave it up for a couple more seconds to make sure that people have a chance to respond. Okay, thank you very much to all of you for spending this last hour with us. We hope that you have a great day wherever you're socially distanced. See you next time.